The entry into force of the EU General Data Protection Regulation represents the most significant transformation of the global landscape of data protection in the past 20 years. It's important to underline that, as evidenced by increasing number of national global aligning these data protection frameworks with the EU, the GDPR is currently deemed to be the global regulatory gold standard for all the reforms in this field. The legislative environment in Africa is also involved in this global convergence towards higher standards of data protection, although the implementation of current initiatives is not coordinated at continental level. In fact, while the various regional economic communities of the continent are trying to promote different instruments of legal harmonization, more than half of African countries do not have any express legislation governing personal data protection at all. From this perspective, the establishment of a robust privacy legislation is fundamental to ensure that innovators and organizations remain competitive in the digital industry. The aim of this lecture is to give an overview of the African initiatives towards harmonization of data protection policies. It will also focus on the main issues that both public and private actors need to address in order to achieve an adequate level of protection of personal data under GDPR standards. After the lecture, you will have an idea of the challenges that African countries are facing in this field and in parallel of the opportunities that they can seize. In the last decade, regional bloc policymakers have made efforts to ensure that data protection and privacy are prioritized by member states. For instance, in 2014, the African Union adopted the Convention on Cybersecurity and Personal Data Protection, with the overall objective of harmonizing national legislation in Africa on a number of ICT topics. The ambitious initiatives, which closely reflects the former EU Directive on Data Protection, have had a little influence since it was adopted. To date, only 3 countries ratified the convention: Senegal, Guinea, and Mauritius. Other initiatives of legal harmonization have been promoted at sub-regional level. For example, in 2010, the Economic Community of West African States adopted the Supplementary Act of Personal Data Protection, added to the Treaty of ECOWAS, the first and still the only sub-regional grouping in Africa to develop a concrete framework of privacy law. The Supplementary Act has also been strongly influenced by the former EU Data Protection Directive and aims to provide a guidance on how to establish an effective domestic data protection legislation and how to facilitate the free flow of personal data within the community. In this perspective, the recent development in this area, like the adoption of a data protection law in Niger in 2018 or the current examination of a data protection bill in Nigeria, show that the ECOWAS initiative has created a fertile soil for West African legislative environment. Arguably, the pathway to achieving a harmonized data protection framework at a continental level is still long and complex. According to the United Nations Conference on Trade and Development, to date only 23 of 54 countries have data protection laws. In addition, the entry into force of the EU General Data Protection Regulation poses new challenges to African nations and companies. In particular, the GDPR places restrictions and adds rules to how the data of EU citizens are stored, used, and collected. Although it is a European statute, the regulation applies to all those who, anywhere in the world, process personal data of data subjects located within the EU, in connection with either the offer of goods or services or the monitoring of their behavior taking place in the European Union. African business must take into account a number of issues and adopt appropriate organizational and technical measures to demonstrate their ongoing compliance with GDPR, such as the register of data processing activities or risk assessment procedures. Moreover, data transfer to countries outside the European Economic Area may take place if these countries are deemed to guarantee an adequate level of data protection. At the time when the GDPR became applicable, no country in Africa was considered to be compliant with the GDPR level of protection. Since the European Union is a major trading pattern for most African countries. Non-compliance with the GDPR could have a negative effect on the volume of trade between the two continents. In addition, there are clear mechanisms of enforcement and significant penalties for non-compliant businesses. Fines under GDPR are severe, with penalties for serious infringement set to a maximum of 20 million euros or 4% of an organization's global annual turnover. If there is no adequacy decision for a country, this does not necessarily foreclose any data transfer thereto. In this case, the organization exporting the data should take measurement to compensate for the lack of data protection in a third country by way of appropriate safeguards for data subject. The appropriate safeguard can be laid down in the following most relevant instruments: binding corporate rules, which are internet policies, and procedures adopted by multinational group of undertaking. After being approved by European data protection authorities, they allow transfer of personal data between different entities of the group. Standard contractual clauses adopted by European Commission or by a national supervisory authority and approved by the European Commission. Customized contractual clauses agreed between the data exporter and the data importer, although they must receive prior approval from the competent national supervisory authority. In conclusion, the adoption of high standards of data protection is crucial to furthering the internationalization and development of Africa's main industries, and most importantly, it will advance African trade and commercial ties with other large consumer markets like the European Common Market.